Great. Welcome to our hot topic plenary panel on comparative law, COVID-19, and racial justice. We're here today with a set of terrific panelists, and I remind you that this hot topic plenary was created to somehow, at the end of our conference, to address some timely issues in which comparative lawyers and scholars are working on addressing issues that are relevant for the world today. So we thought that COVID-19 was certainly one of the best issues we could address. And for this goal, we have 4 terrific panelists. We try to gather panelists that work comparatively in different areas of the law. And so let me start with our first panelist. What we're going to do is to divide their presentation into 3 questions that I will ask, and each of them will have 5 minutes. So let me start with our first panelist, who's here to my left, and she will address international law and law and development, is Nneoma Nwogu. She's a senior counsel at the World Bank. She provides legal representation on corporate matters related to development finance, including legal advisory services on specific funds and operational matters. She co-leads the World Bank Legal Vice Presidency Working Group on Technology and Innovation, and she also worked on the COVID-19 Taskforce. She received her BA from Wesley and Phil from Oxford, and JD from the University of Michigan. She's a term member of the United States Council on Foreign Relations, adjunct professor on development finance at American University, Washington College of Law. Our second panelist addressing comparative constitutional law is Professor Mila Versteeg, who joined UVA Law School in 2011, and her research and teaching interests include comparative constitutional law, public international law, empirical legal studies. The publications have, among others, appeared in the Harvard Law Review, Columbia, New York Law Review, and she has a new book forthcoming called How Constitutional Rights Matter with OUP. And in 2017, she was named Andrew Carnegie Fellow to expand her research into the world's constitutions to better understand how constitutional rights are enforced in different countries. One of the main reasons she's here, not only because of her incredible background, but also because she just co-authored a paper, a very influential paper with Professor Tom Ginsberg entitled The Bound Executive Emergency Powers During the Pandemic. Our next panelist, and this is the order of the questions I will ask, is Dominique Day, and she will address international human rights. And Dominique is the chair of the UN Working Group of Experts on People of African Descent. This is a fact-finding body mandated by the UN Human Rights Council, and they have to investigate and report on the situation of people of African descent globally. And in this respect, Dominique has prepared a recent thematic report entitled, you can all read it, I'll put it in the chat, COVID-19 Systemic Racism and Global Protest. She's also a human rights attorney who leads Daylight, which is an access to justice platform. Internationally, her policy and capacity building work focuses heavily on racial justice, and she has extensive criminal and civil litigation experience on behalf of individuals and communities of color. The very last panelist is Neysun Mahboubi. He's not here yet. He will arrive at 1:45, so he will join us soon. But let me introduce him. And the reason why he's our fourth panelist is because his expertise is on comparative administrative law. So we have a good mix of public law, international law, and Neysun is a research scholar of the Center of the Study of Contemporary China at the University of Pennsylvania. He's a lecturer at Penn Law School. He hosts the Center for Comparative China podcast, which is a terrific podcast if you haven't heard it, and it's one of the project leaders for the Penn Project on the Future of U.S.-China's Relations that is putting a lot of papers out there for the future administration. His primary academic interests are in the areas of administrative law, comparative law, Chinese law, and the reason why we invited is also because he recently put together for the regulatory review a comparative administrative law symposium on COVID-19 called Administrative Responses to COVID-19, and he authored the introduction. So without further ado, we'll start in the order that I called the panelists. So we'll start with Nneoma, and then Mila, Dominique, and Neysun. And the idea is to engage with my first question, and I will give 5 minutes each. And when your 5 minutes are up, I will just put my hands here. I will just say 1 minute and then 0. Okay, so let me start with our first question, that is, how did you use your different legal expertise in tackling COVID-19 challenges? So, pretty broad. Please, Nneoma.
Thank you. Thanks, Fernanda. And also I want to say thanks to the American Society of Comparative Law for giving me this opportunity to participate in this very interesting discussion. And Fernanda, I must say, I'm also timing myself so that I don't sort of keep going. And before I start, I also want to say that I'm here in my capacity as an adjunct at WCL and not in my capacity as a senior counsel of the World Bank. So that is really to say that whatever I say here, all of the things I say here do not reflect the views or opinions of the World Bank or any of its members. So having said that, I think, you know, coming from the international law and development finance perspective, I'm gonna just set the context here, and we can talk through as throughout this discussion on what is to be problematized in that context. If you think of the bank ultimately deploys its own financing and mobilizes funds that the bank administers in trust on behalf of groups of donors that are legally structured to be either sector specific or region specific. So if you think about buckets of financing, this is how it works. So ultimately we have different buckets of legal analysis. There is the board policies that are sort of under international law when you think about the bank's constitutive article that then generates the policies and procedures that guide the bank. So the board's decisions with respect to how we deploy financing. Then we have the agreements that we sign with individual donors who are contributing to specific funds. And then we have the downstream agreements that are the agreements that we sign, the financing agreements that we sign with recipient countries. So when you think about the agreements with donor countries, contributing donor countries, and the agreements with downstream recipient countries, there are legal frameworks, domestic legal frameworks that shape the negotiation of these documents. So of course, in a pandemic, some of these things will bring to bear. And I want to focus on just a few of those. We have to remember that COVID-19 is actually very different from an Ebola type crisis because it affected pretty much every part of the world, including and in many ways devastatingly for the donor countries. So some of the high income countries that are not our client countries were quite impacted by this. So the mobilization of immediate resources from donors had to be done in a specific way. And so what we ended up doing in that context was a lot of restructuring of already existing funds rather than the mobilizing new funds in that context. And the question was like, how do we do that? Because there are a number of structures and frameworks that determine what is to be financed. So for example, if trust funds were established as sector specific in agriculture and we don't have enough funds in the health sector, and in the context of the pandemic, these funds had to go into the health sector. How do you restructure those legal frameworks in order to get funds into the sector? And we'll talk about that when we talk about what we did and the recommendations that we have going forward in the structure of these funds. And then downstream, we had a very interesting dynamics, and I will think of Ethiopia and Malawi, for example. So Ethiopia has a nexus of a number of things. Ethiopia was a country where you had in a sense, a hub right? Because of its airlines and its sort of entry points into the rest of the African continent, and also its particular sort of travel corridor between China and Ethiopia, specifically. But also on the African continent, it had the oldest sort of public health system. So a little bit more established than a country like Malawi. So Malawi is more landlocked and not a hub as compared to Ethiopia. And to see with Ethiopia, there were a number of things in place that allowed us to move a lot quicker in that context. So let's put it this way. First, beginning of March, the bank established a task force and also announced a facility, a COVID-19 fast track, as it was called, fast track facility of about $12 billion, $6 billion of which basically was to go to IBRD and IDA. Those are the two institutions of the World Bank, as opposed to the $6 billion that went to the IFC for financing of the private sector aspect. So you have that, and the need to deploy those funds very quickly. And then you had existing frameworks. We had issues where the mobilization of resources domestically, so in terms of the laws and the procedures for mobilizing these resources domestically, so in some countries were problematic. So some of those, for example, is parliamentary approval of loans by the World Bank. In some countries, that is part of the enabling legislation that is constitutionally established. So in that kind of context, how did we try to get around these kinds of issues? But another is in terms of the bank's own articles as a treaty, in terms of a development purpose, we needed to ensure that there were emergency preparedness and response plans in place to basically create the eligibility for what we were funding. So were there countries that had that, and were there countries that did not have that? And some of those are the things that we'll unpack in this process. I will give a few more examples as we start to unpack this discussion. Thanks, Fernanda.
Thank you, Nneoma. And please, Mila, and remember that at the end, everybody can put their questions in the Q&A function of our chat. Please, go ahead, Mila.
Hi, thanks so much also, Fernanda, for having me here, and for everybody who's in the audience for listening. So I work in comparative constitutional law. So as somebody interested in comparative constitutional law, of course, this unprecedented situation raises a lot of different questions. So I will maybe talk first a little bit about where I started looking for answers or the questions I started asking. And then later in this session, we'll talk a little bit more about what I actually ended up researching. But it's worth noting, first of all, I think that probably never before have we, and maybe I'm wrong, but I think at least in many parts of the world, we've never before seen such a major drop in civil liberties all at once, right? In places where people usually take their rights for granted. So it's really an unprecedented situation in that respect. And one of the first things I think as a constitutional lawyer that I was interested in is like, where do governments get the legal powers to impose lockdowns and to place restrictions on civil liberties, right? So what is the constitutional basis for doing so across different systems? Because it's an unprecedented situation. And in many countries, it's set of heated debate. What are the powers of the government to do so? So together with my co-author, Tom Ginsberg, we've as the pandemic started and we were stuck at home and like wondering about the world, we started documenting basically, first of all, what the legal basis for the response was across different countries. So we followed some 100 countries over a 4-month period and tried to, with a team of research assistants, to document like what kind of powers did the governments invoke. And I guess one finding we had there is that there's 2 broad models for government powers to impose the kind of restrictions we've seen during the COVID-19 crisis. So first is to invoke a state of emergency under the Constitution. Turns out most countries have constitutional emergency regimes in their constitutions. And when they're invoked, right, when an emergency is declared, usually by the executive, then additional powers flow to the executive. And the traditional insight is that during that time, rights can can be suspended or derogated from, as we say in international human rights law, though not all rights, but at least some. And courts may not have a really big role to play in this when there is when we're in a state of emergency, right? So that's one model. The second model is actually to simply rely on legislation, right? You don't have to invoke a state of emergency. So it's possible for the legislature just to delegate certain power to the executive, usually the executive, to take measures to combat the crisis. So it turns out a lot of countries had infectious disease legislation on the book as the crisis started that they invoked. In some cases, in the case of India and Pakistan and Nigeria, I think this was actually colonial legislation, but yet it was used to impose the lockdown that we saw in India, for example. But interestingly enough, if this is the framework you're in, then the ordinary constitutional framework stays in place, right? So rights are never unlimited under a constitution. They can be restricted if there is other important goal, as long as doing so is necessary, proportional, mandated by law, and so on and so on. And in those cases, judicial review also stays in place, right? There's no reason why courts can't scrutinize these actions or new legislation that's being passed, which is another way of that you could see this legislative model, if you want to call it, of responding to the crisis. So Tom and I, we looked into like what basis did countries use, and we found actually both are used pretty much equally. So some 52% of all the 100 countries we followed relied on legislation. Some 40% invoked a state of emergency under their constitution, and then the remaining handful of countries were basically authoritarian regimes that never clarified what they're doing. Turns out that's possible too. And our initial hunch as we started looking into this, was that this probably matters. My sense was, invoking a state of emergency is a more severe measure. It means that rights are potentially derogated from or suspended during this time. It means that there may not be a role for courts. Whereas if you use legislation, then your ordinary constitutional framework stays in place, and that's probably better. That was my hunch. But as we started looking into the countries that did each, it was not so clear that this actually did matter. So we felt this is maybe too formalistic a way of thinking about it, as in we see no real difference in which model is used between authoritarian regimes and democratic regimes. And then as I'll say a little bit more about in a second, under both of those models, you see in some cases, there be real checks and balances on the pandemic response, and in other cases, not, right? And these checks and balances, we've seen courts involve themselves in state of emergency declarations. And we've seen also courts not doing anything about new legislation that's being passed that seems problematic. So the question we started as comparative constitutional lawyers researching is, what are the legal basis for this response? But the question we actually ended up writing about, or that became the core of our project, is to what extent is there a role for different branches of government, including courts, maybe subnational units, legislatures, and so on. So to what extent have we seen checks on these tremendous powers, institutional checks on these tremendous powers that these executives suddenly have been exercising? Okay.
Terrific. Thank you, Mila. Welcome, Neysun. We're all asking the one question: how did you use in your different legal expertise in tackling COVID-19 challenges? How did you use your expertise? And now, please, Dominique, go ahead. And I put your report on the chat, so the UN report that Dominique co-author is on the chat.
No, so thank you, and I'll add my thanks for this important conversation. I think it's really timely and necessary. The work I do is largely in international human rights, and when we talk about human rights, we're usually talking about individual rights, individual freedoms, and the ways that they're protected. I look at things along racial justice lines, and there's something really interesting and very telling, especially at a time of a global pandemic, to look at how people's individual rights are actually impacted in very consistent and common ways across racial lines, even in very different spaces. And we saw this immediately with COVID-19. Maybe I'll talk a little bit more later about it, but we saw immediate disruptions in supply chains to the global south. We saw immediate understandings that this would hit people of African descent and some others disproportionately, and in fact that happened. And so what we did from the beginning, and this is sort of how we operate, is ask this question of whose stories are not being told here. This idea that sort of the most vulnerable populations are the people who often face the biggest challenges to access and enjoy their human rights, the idea that they would also face a similar parallel challenge in COVID was kind of out there. People kind of accepted it, sort of. At the same time, we were all inside of a narrative of we're all in this together, the virus does not discriminate, this is something we all have to deal with, which didn't necessarily turn out to be true, right? We saw from the very, very early days that we were not all in this together, and that in fact, it's not that the virus discriminated, it's that the policymakers and the political priorities discriminated. And to be honest, right, the ways in which states define their self-interest involved a tremendous amount of discrimination that absolutely impacted outcomes across racial lines. So when we started looking, right, and early on in this space, we're saying whose stories are not being told, what's actually happening out there. We live in this moment where we love big data sets. We feel like the reliability of information is only corroborated by massive data sets that offer something more objective than an individual person's story. And you know, you're not going to hear me complaining about data. I have a whole spiel I can give about the importance of data disaggregated by race for just this reason. But at the same time, especially early on in the pandemic, and especially in terms of understanding the nuances that may not be captured in our data collection because of both variables, sort of like ideas or issues that are not necessarily predicted and we're not necessarily, selected for as we ask questions, as we gather data, right? Ultimately, on some level, we need to hear the narratives of people to understand what novel and unique issues might be driving people's experience of COVID and might be driving both the limitations and the violations of the human rights space in this moment. And so, so for us, looking at people's individual stories has been very, very telling. For those of you who do, who embrace feminist theory, you know, we call this the politics of the everyday, the understanding that the individual story, what's happening in local, intimate spaces can really be very revealing in ways that a large data set may not be. And that, in fact, that individual story may be more telling of a phenomenon or of a community or even of like in our case, a transnational racial issue, than even a big data set, than even the statistics on who's dying. We've seen that people of African descent have faced increased mortality, increased infection, increased severity. But on some level, the stories that we've heard around the kinds of risk that they were being asked to tolerate maybe even more telling of what's been happening in COVID and how, in fact, we've seen prioritization in this space. So we very much are story-driven. We're very much a report, which I think is in the chat, really relied on a call for submissions globally, asking people what's been happening, what are you experiencing? Is this global pandemic the same for you as it is for your neighbors with more money, with white skin, with more power? And then ultimately, how has your state, how have states really construed their own obligations to social protection, their own obligations to protect the human rights of their citizens as the pandemic unfolds? I think Mila and Nneoma talked very provocatively around the way systems were supposed to operate. And yet in our call for submissions, we very quickly started hearing about impunity on multiple levels, right? So you know, many states did actually have executive orders or some kind of legal framework, but then the operation of it often involved the deployment of police, the discretion of healthcare providers, the discretion of people with pots of money that may not have actually reflected the most narrow construction of what pandemic emergency looks like, and instead reflected a lot of impunity that may have been grounded in things like stress or fear or resentment, right? And that was a space that we quickly saw.
Perfect, thank you. A very diverse intervention. Now, welcome Neysun, please go ahead.
Hi everyone, and apologies for being late. I was on a different Zoom panel that just ended, so I'm spending a lot of time on Zoom today. So I know that the initial question invited each of us to speak about our particular area of law and how it's addressed the COVID crisis, or what we can learn about how COVID has impacted our field of law. So I'll take a few minutes to say a few things about my field of administrative law. And in particular, I want to first highlight a series of essays that together with my senior colleague at Penn, Carrie Colanesi, we organized for the Regulatory Review, the online platform of the Penn Program on Regulation. And so the series of essays that I see is also in the, or at least you have the link to my closing essay, but you can also follow that to read all the essays. Altogether, we have about 40 essays in that series covering about 22 countries. And we have contributions from a number of people who are active in the society, including our chair today, Fernanda. And also, off the top of my head, I can think of, we have an essay from Jacques Delisle on China, Eric Feldman on Japan, and many others. And so I had an opportunity, because of organizing the series, to kind of look at the broader points that were being made across the essays, and to think a little bit about what could be gleaned about the role of administrative law and regulation in addressing this crisis, and how the crisis has put pressure on administrative law and regulation. And from my vantage point of reading these essays and thinking about them, a few conclusions sort of came to mind. One, it seems to me that it's fair to say that those countries that have seen a particular rise in anti-regulatory sentiment, often linked to populist political leaders in recent years, have done particularly badly in addressing the COVID crisis. And sort of the chief of those, I would say, are the US, unfortunately, the Brazil, certainly, and the UK as well. And we could probably come up with some other examples as well. So there does seem to be some connection between the degree to which a country takes a regulation and regulatory process seriously and how well they've done in addressing the pandemic. Getting more granular, one of the things that seems quite important for handling the pandemic is good coordination between different levels of authority, whether between the central state and provincial authorities, or provincial authorities and local authorities. Having good lines of coordination seems to be important. And it's not really an argument for a particular form of coordination. If you read the range of essays in our series, you'd see that a number of the places that have been successful have had different kinds of coordination. The kind of coordination that we have in Germany, that Johannes Sauer wrote, and the kind of coordination that Fernanda wrote in Italy are actually different, but they're functional. And the lines of authority are clear, and the information sharing is well done. And so that seems to be quite important. That's something that administrative law can help with. A second point that seems clear is the importance of expertise and of government processes taking expertise seriously. In those countries where scientific experts have had an ability to shape the government's pandemic response, they have tended to do better than in those countries where scientific expertise is denigrated or set aside in favor of other values. That connects in turn to, I think, popular trust in government. And that's been one of those things that's been really remarkable to understand for me, is that in those countries where there is high level of trust in government, which is connected in turn to being respective of scientific expertise, the steps that the government has had to take in its pandemic response has not had to be that heavy-handed to be effective. And some examples of that could be Taiwan in particular, and also Japan, where there is enough trust in scientific expertise and in light signals from the government about how to conduct your daily business in a safe way in light of the pandemic, that there was no need for very intrusive lockdowns. The messaging in and of itself, and New Zealand is another example of that, where the messaging from the government authorities was sufficiently well respected and followed in people's daily lives, even for such simple things as mask wearing or being careful to self-quarantine if you've had exposure. Those have been very effective. And then that'll lead to the last thing I'll mention, which is communications. clear communications from governmental authorities seems to be much more important, really, than how intrusive or heavy-handed their methods are. Now, we clearly have some examples of countries like China, which everyone knows I study, where you have had very heavy-handed tactics. You've had really severe lockdowns. You've had things that probably would raise all sorts of civil liberties concerns in the US context and in many other countries as well. But one lesson that I've drawn from reading these essays is that while those tactics may have worked in China, and we can talk about that certainly, they're not strictly necessary for effective pandemic response. It's simply having a clear, consistent message from governmental authorities about the nature of the risk, about the steps that one can take to mitigate the risk, and have that message be clearly coordinated between different levels of authority, which are all things that a healthy functioning administrative regulatory state can do, is extremely successful and effective in handling the pandemic.
So let me go back to Nneoma now, and to some extent you all talked about this, which is what role does law have to play in this global pandemic and emergency? And also I want to address Dominique's point is like what the law does or does not do in this global emergency. So please go ahead now.
Thanks, Fernanda. What is really interesting is sort of looking at some of these things. Of course, when we're looking comparatively, we're looking in some ways sort of domestic to domestic basis. And, they say that, for a hammer, everything is a nail, but for a pandemic, by its nature, it is not something that is sort of in some ways encapsulated and bounded, right, by country. It's necessarily global. So as much as we talk about the need for, particular processes, particular legal frameworks domestically, there's got to be some interconnection and interaction in terms of those laws to, at a global level and in a sense, state or international level. And I'll speak to this in some of our experiences. But one of the things that I wanted to put out here first is like pretty much on every few days we get an update on our client countries and how they're doing with respect to COVID. The last report we got came out on Tuesday. With that report, IBRD countries most affected is India, Brazil, Russia, Colombia, Argentina, and Peru. IDA eligible countries most affected are Bangladesh, Pakistan, Nepal, Ethiopia, Honduras, and Uzbekistan. When we talk about in terms of incremental net additional cases, over the past, since the last report, which was sometime last week, you have Solomon's Island, Uganda, Guyana, Nepal coming into the picture. So there is, for the most part from our data, it seems like IBRD eligible countries are the countries most affected. They have about over 60% in terms of global cases. So we're kind of often hearing in the news about more high income countries. And as Dominique was saying, it's important to actually, when you look at the data, start to see how this, how the cases are sort of distributed as a general matter. But in terms of how the law impacts, again, coming from that international perspective and law and development perspective, has got to be that there has to be both regional and global harmonization of these quote unquote domestic systems, because it impacts how you mobilize the resources. And I don't mean just monetarily, but even in terms of goods and services that are deployed to address the pandemic. This is something we found to be critical in the ability to deploy, because we could deploy finances, but could these governments actually access the goods and services they needed to address the pandemic? We were talking about hazard pay in some of our financing activities to finance hazard pay for essential health workers. What if we're working in countries where you didn't have the capacity, speaking of expertise? How did you deploy? How could you move capacity around in order to address the needs where you have the most needs? So these were some of the challenges that the bank had. And at some point we had to actually intervene with an additional legal measure to allow the bank to stand in the gap in some ways to negotiate on behalf of governments within the global market for goods and services that they couldn't otherwise access through what we call the BFP, Bank Finance Procurement, bank-supported BSP, bank-supported procurement. So that there can be some leverage in these negotiations. You know, as we've mentioned, in some of these cases, there may be instruments that exist, but in the context where there were gaps, we found that it just felt like the law was sort of pushed to the side, processes were pushed to the side. In emergency deployment of financing, especially from the bank's development purpose mandate, to be able to monitor this financing, that was one thing. Another thing is limitations, prohibitions on what we could finance, where you have law enforcement getting involved in sort of addressing the social aspects of the pandemic, the implications. How could we do that within the legal framework of the country? So these were some of the issues that came up for us. So I definitely think some, you know, global response plans, global instruments, maybe in the form of treaties, you know, in terms of when we're talking about what laws, because this I mean, we already know that pandemics are going to be, you know, much more a thing in the future. So we have to figure out how to address this on a global level. And as we've talked about as well, where I think part of our challenge has been the lack of the global mobilization that needed to happen in this context, whether we're talking about also just mobility as a whole, and as I mentioned, the movement of these goods and services. And perhaps in the next section, I will talk a little bit about, you know, specific issues in terms of data, in terms of signatory authority, some of the challenges legally that were specific country to country that we were experiencing and finding ways of addressing them. In some of the bank's established treaties, we already had crisis response windows. Okay, you know, like ways of being able to deploy money, but again, the absorptive capacity of countries was something that was a challenge for us. So I'll leave it there for now.
Terrific, thank you, Nneoma. And the gap of international treaties is very interesting. Please, Mila, go ahead.
Yes, okay, great, thank you. So when we're thinking about constitutional law in times of emergency, I think a very influential view, I'm not sure if I would call it mainstream, but certainly very influential view, is that constitutional rights during an emergency take a back seat for a while, and if anything, more power flows to the executive branch, right? So emergency power is executive power. This is an idea that goes back to Carl Smith, but has many proponents in this day and age, most notably the work by Eric Posner and Adrian Vermeulen, who have argued when faced with an emergency, courts really should step out of the way because they're particularly ill-equipped to deal with crisis. They're slow, they're way too open, right? We can't do anything secret and fast when we go to court. Legislatures are not gonna wanna put their neck out, and also they're too slow. So really what we need is to have power go to the executive branch. And these ideas are of course contested, right? These sort of neo-Smithian view, it's of course contested normatively, but empirically, I think a lot of scholars agree that during a crisis, a lot of power flows to the executive branch. And in some ways, it's what I heard Neysun say when he said, well, what we really need is a smooth administrative state operating well, right? A good executive apparatus. But I think, I mean, as I mentioned before, the study that Tom Ginsberg and I've been doing, trying to document involvement by other branches of government in the pandemic response, it's not really what we have seen in many places around the world during this pandemic. So as I mentioned, Tom and I started researching what are the formal legal basis for the pandemic response. But then as we were doing that, we kind of were struck by courts involving themselves in these questions very quickly. So the first court to get involved was the Constitutional Court of Kosovo, which struck down an entire lockdown order as unconstitutional because it was based on executive action alone and not legislation. It says, you know, we'll give you 2 weeks to fix it, and then legislation was passed and the lockdown stayed in place, but still it involved itself on procedural grounds. And then in short succession, we've seen a range of very interesting cases, right? The Constitutional Court of Malawi saying you can't lock down the country unless you have measures in place to protect the poorest of the poor. And after the government had some cash handout program for the country's poorest, then it locked down. Or the German Constitutional Court saying you can't ban protest entirely. If that's disproportional, you can protest with social distancing measures in place. Or a Brazilian court, this is the one I may like the most, that imposed the lockdown in a part of the country where a healthcare system had collapsed. But then in Pakistan, we actually see the Supreme Court just lifted a lockdown because it's for violating the right to conduct one's business. So we started taking the paper in this direction. We're like, hey, this emergency doesn't really fit with our traditional theories of emergency and the role that law plays in times of emergency. So in our survey, we document to what extent have courts been involved, to what extent have legislatures been involved, and also to what extent have we seen subnational units be involved in the pandemic response. So we found, just to give you some numbers, even though obviously they're relatively superficial, but in 64% of the countries we looked at, there was some involvement by the legislature, either in terms of passing brand new legislation or authorizing an emergency. And in some 68% of democratic countries, we actually saw an ongoing involvement by the legislature, whereby they had to not only pass the initial legislation or approve of the emergency, but also extend it after some while, because emergency powers and constitutions are often temporary, or they established parliamentary oversight committees. On courts, we found that in 55% of the democracies we looked at, there was actually courts that got involved, and not only got involved, actually struck down or modified part of the COVID response, usually in the name of constitutional rights. And we found 3 types of cases, some procedural cases where courts basically say you have to follow proper procedures, either in declaring your state of emergency, or if you're using legislation, there needs to be a legal basis for the response, like the Constitutional Court in Kosovo did. But we also see courts doing substantive rights review, just saying, are these restrictions that we see placed on rights or limitations, are they necessary? Are they proportional? And are there ways to do that are more proportional than what the government has done, right? The German case that I mentioned is an example. And then third, we actually see courts requiring the state to take action, right? And this is especially possible in countries that have, well, in most countries that are not the US and don't have a state action doctrine, basically. So for example, in Brazil, we've seen a lot of very interesting court cases, amongst other, the highest tribunal saying the government has to make that data available. Bolsonaro has to wear a mask in public. In Zimbabwe, the Constitutional Court saying the government has to provide PPE to workers or healthcare workers. See this diverse range of involvement. And interestingly enough, I mean, Kim Shapley and David Posen have this interesting paper, which is called Executive Underreach, right? So one of the puzzling things about this pandemic is the executives that haven't done much at all. And there you also see courts step in some cases. And then finally, and then I'll shut up, is we looked at the role for subnational units, and especially resistance from subnational units, either in federal systems or in unitary states. And we actually see in some 34% of the countries that there was outright defiance by subnational units, whereby they said, okay, yes, we're imposing our own lockdown, or we're imposing a stricter lockdown, or something along those lines, which is a very different mode of coordination, I guess, than what Neysun was describing, but we can talk about that more. Okay.
Thank you, Mila. And please, Dominique, go ahead.
Oh, thank you. And I really want to echo, I really think it's very powerful what the 2 first panelists have said here, because what we see, when we talk about the rule of law, we think of it as an alternative to vigilante behavior. We think of it as an alternative to unpredictable, unlicensed action by the people with the most power, or the most guns, or the most might, right? And that's how we promote rule of law around the world. We say in our own countries, we live inside of a rule of law that involves considerable amounts of planning for emergencies, right? We have civil rights laws. We have limitations on how the police may approach citizens for emergencies, because in ordinary times, the police shouldn't have to be approaching citizens much at all. So we have all of this law and all of this information that's set out for emergency situations by law, by contract. And we have it around the world, and yet a lot of what we saw, I think despite what's been said, was really the abandonment of that. And the need, I think Nneoma spoke about the bank stepping forward, Mila spoke about different governmental institutions stepping forward, but the need to somehow reassert or remind even very powerful states that consider themselves human rights advocates, the need to reassert or remind them that in fact, we've made some decisions around global solidarity. We've made some decisions around international cooperation, and that they have obligations beyond their own sort of knee-jerk reaction in protection of themselves or their citizens. And even so, we saw very troubling things, right? So in terms of failures of the supply chain, I think I touched on it for 2 seconds earlier, but immediately in March, as the pandemic rolled out, all of a sudden, ordinary medical supplies, ordinary surgical supplies that were part of the sort of aid, the aid process, the aid network, were immediately cut off from Europe, from the US, going into the global South, into Africa, into South America, things that had already been procured, humanitarian supplies that had already been promised, that had nothing to do with COVID whatsoever, were immediately stopped. So shipments were stopped and they were retained. In the United States, even aside from aid, purchases, procurements that were paid for by countries in Latin America and the Caribbean were disrupted and hijacked, right? These are not just one state with maybe a questionable political leader acting in a rogue manner. These are disruptions of international cooperation. These are abandonments of key international human rights and key international law provisions that exist, that are on the books. And so these aren't small things. At some point in the US, right, and this is with the acknowledgement that the US was and is being very hard hit by COVID-19, but also has a health infrastructure that is, you know, unparalleled when you compare it especially to the global South. You know, in the US, at some point, USAID, the development arm of the US executive, was instructed to reach out to all of its beneficiaries and ask for the return of personal protective equipment, masks, gowns, and information that had been handed out or was to be handed out as part of the aid framework, so that the US could actually have these materials to fight its own COVID-19 battle. That is unthinkable, right? That the richest nation in the world, facing global pandemic, facing emergency, would actually look to take from people who are de facto worse position. But we saw that, right? We saw these really provocative failures of international cooperation, despite the fact that we have aid contracts written, despite the fact that we have tremendous amounts of law and policy that should support the automatic continuation of these networks, even in the case of emergency. But we also saw this internally, right? We saw tremendous police violence against people of African descent. We saw this, sure, in Brazil and in Peru and in Colombia, but we also saw it in the United States and in Spain and in the UK. And in fact, it's been documented that somehow the stress relief for the policing arm of the state seemed to be to exact violence on the people most at risk of global pandemic. And then I think the last thing I want to say, we also saw the way that different accommodations reflected political and not public health priorities. And maybe this is the sort of consequence of this retreat to the executive that Mila was talking about. And maybe for sure this explains how, why the bank's actions to sort of stand in became necessary, because we saw a tremendous amount of behavior that you know, if you're in the sandbox, it feels a little bit like bullying behavior. We didn't see people most at risk being most accommodated. And I think a challenging aspect of this is we also saw this almost relief in retreating to like a cowboy behavior. there was a pretty interesting, I mean, I'm not even just talking about sort of policing. The head of the emergency department at NYU released a statement early on saying, we're not going to have the luxury of committees or thought to think about what it looks like to triage care, who gets ventilators and who doesn't. Even though we know that that's a recipe for racial bias, that's a recipe, this level of unbridled discretion creates the kind of racism that gets people who look like me killed. And so it's been interesting to see the way so quickly people were willing to abandon the law.
Neysun, please go ahead. Sorry.
Sure. And so I take the question to be, a deeper look at what is the role of administrative law in handling the pandemic. And it seems to me there are a few different areas that we could focus on. So first, we could focus on just initial detection. What is the role of regulatory processes in detecting the emergence of a novel coronavirus? And of course, we all know that the story on that issue with respect to COVID-19 has to do with China. And so I would direct the audience to take a look at the essay written for our series by Jacques Delisle, where he really outlines what were the administrative failings that led to the delayed basically like processing of this is a new issue that we have to deal with seriously. Another in the Chinese context. Another set of issues are around mitigation. Once it's been detected, what are the different ways in which the government can mitigate it? And I've already, I think, gone over some of those main points, so I won't repeat them here. Coordination, the importance of expertise, clear communication strategies. But it's important also to realize that the pandemic presents other kinds of issues as well. So another kind of issue is once you've set these obligations, these ways in which you're limiting the ability of private actors to conduct their businesses because you're trying to mitigate. Once you get to alleviating those obligations, there's another role for administrative law there. And in our series, Carrie Colanesi has an essay on that. Assigning responsibility. Once the dust is settled, I know there's a lot of discussion of the role of courts in that initial phase when parliaments or executives in particular are assigning to themselves greater power to address the pandemic. But there's maybe that set of issues is more in Mila's domain of constitutional law. But there is also a later place for my type of the role of courts, which is judicial review of agency action. All those things that I've talked about, the steps that were taken or taken badly to detect the emergence of the novel coronavirus, the steps that were taken to mitigate it, the steps that were taken to lift obligations on private actors, all of those are clearly things that courts can handle and will very likely handle in the future in different ways. In China, obviously, there's going to be some more limitation on the ability of courts to really dig into those issues, but some of the ancillary issues, I'm sure, are going to get at least attempted to be brought in Chinese courts. For example, and when I say ancillary, I mean something like the ways in which the vaccines are being put out into the Chinese population maybe a little sooner than there ought to be. Actually, just a year ago, maybe 2 years ago, the Chinese legislature passed a new law that makes it easier to bring cases against vaccine manufacturers for defective vaccines in light of a vaccine scandal that led up to that. And I'm sure that as the Chinese state proceeds with putting this vaccine out into the population that we're not entirely sure is safe and effective, I'm sure that's going to be a basis for suits going forward. We could also talk about at the international level, like the way in which the WHO in particular, and maybe other international institutions address the pandemic can be a question of administrative law. I think in our series, Oswald Jansen has written a piece where he talks about the administrative law deficiencies of the WHO in terms of participation and transparency and how those things had a role to play in its deficient response to the pandemic. I do want to add one last thing, which takes me a little bit outside of my lane of administrative law but is more of a general reflection on the role of law generally in dealing with a pandemic like this. And it has to do with essentially societal comfort with wearing masks. One of the things that's very clear when we look at how Asian nations have dealt with the pandemic is that a higher degree of social comfort with wearing masks has played an enormously helpful role in keeping the pandemic relatively in control throughout Asia, whether you're talking about China or Japan, Taiwan, South Korea, Vietnam, all of which have slightly different governmental responses. China has a very intrusive response. Taiwan has a very unintrusive response. But throughout, you have societal ability to handle wearing masks relatively easily. And I don't think that has a lot to do with administrative law. It almost has something to do with culture. And I say that because I want to provoke, you know, all the people who are watching this who are immediately going to get upset if I talk about culture in any essentialist way. And so I'm going to roll it back to say that I don't mean it essentialist, but culture can be constructed. And in a number of these countries, there was a prior experience with something like this. In 2003, you had the SARS crisis. In 2015, you had the MERS crisis. And that seems to have taken people to a place where they're more comfortable wearing masks. And it's pretty remarkable to me as a legal scholar who wants to think that law is incredibly important, that something as simple as whether individuals are culturally more willing to wear masks can have such an enormous impact in how well a country does in dealing with the pandemic.
Great, thank you, Neysun. And the mask is a great example how changing culture can actually have a huge effect. And through your findings as where you are situated as an academic or as a World Bank officer or in the UN Human Rights Council, if you have any recommendations of what your research has pointed to, like uplifting, silver lining examples, or maybe not. What are your recommendations in addressing this crisis or emergency? Thank you. We'll go again back to Nneoma, who started on this issue. Please. You should unmute yourself, Nneoma. You're muted. Yeah.
Thank you. Thanks again, Fernanda. I guess in terms of findings and recommendations, flexibility has been the name of the game in terms of particularly restructuring of existing rules and existing financing structures that we had. So I gave the example of trust funds. We had mining sector trust funds that wanted to address COVID. The initial question would be, especially in countries in the Sahel, as well as in DRC, for example, where sometimes mines were late to close, or if they closed, these miners did not have access to any kind of social support. And we had trust funds for mining governance that was trying to figure out how do we support, the impact, the COVID impact on these mining communities, right? So we had to start, to engage in some both interpretation and restructuring of the legal documentation with different donors to whom it was acceptable to do this in order to put funds towards supporting this subsector in a sense, respond in terms of social support, not health, but still find a way of mobilizing resources for this sector. So that's one thing. But another thing I think is the bank had already been working on, and the board had already had discussions on mainstreaming disruptive technologies for development. And it's important to mention that a lot of the research on whether it's COVID or just more generally on some of these issues, there are recommendations that tend to come out at a global level that doesn't look at the intricacies of some of the, as Dominique was saying, some of the hard hit or, the people who are in most need of the support in the context. So let's take vaccine financing, for example. So there's been a global facility set up called COVAX for financing of vaccines and deployment of vaccines globally. But some of the questions that weren't coming up initially was exactly whether you actually had the instrumentation in domestically for some of the IDA eligible countries to actually deploy these vaccines. And so we had to come up with ways of supporting these countries in preparation for the deployment of vaccines in this context. So there was that, but I think the fact that the board had already been discussing this allowed for a situation like COVID, where our board was basically making this, decisions virtually. We had our experts who were grounded in wherever they were, but couldn't, in a sense, go in country to provide their services, expertise in the context of the COVID response. How do you deploy expertise in that context? Because most of the countries that we work in usually lack the expertise domestically to address this kind of novel issues. So these were things that the bank had already been contemplating in the context of the disruptive technologies framework. That then, whether we're talking about use of drones for transporting of COVID testing, I forget the phrase now, but in terms of some of the testing kits, the ability to transport that across countries in Ghana, for example, the deployment of that technology, in terms of also data, the management of the data that had to be collected in response to the COVID crisis. So these were already things that were already in place to some extent, or developing, that we're able to deploy a little bit quicker in that context. I would say that it is so critical that going forward, I kind of want to reiterate this notion of international cooperation that Dominique mentioned, that is not just about the overall sort of overarching frameworks, but the procedures that ensure that the solution that we're talking about gets to the person, gets to the, to the individual in the place where it's needed the most. So that is not just theoretical ivory tower, but it actually gets there. So law, for it to be relevant, has got to be practical. It's got to get from the very top to the very bottom. And so I think that's what I would say in terms of recommendations, or at least areas of research, how we get from the overarching ideas to the very practical issues that need to be solved, especially in a health crisis.
Thank you, Nneoma. And next, please, Mila, go ahead.
Yes, thank you. So I'm not sure if my recommendations are all that practical, but I'll try anyway. So I think from the perspective of comparative constitutional law and comparative constitutional or just constitutional theory, it is important to rethink our notion of what emergency governance should look like in an emergency like this, like a global pandemic, and what role there is or should be for different parts of the government, notably courts and also subnational units, cities, states, right, provinces, and so on. Because I think a lot of the sort of conventional wisdom that we have, or the traditional ideas about emergency powers, that emergency power is executive power and law basically runs out in many cases, were all developed in the context of national security threats, right? Wars, foreign invasions, 9/11, maybe the 2008 financial crisis. But I think, and Tom and I wrestle with this in our paper, we have this hunch that this is a different type of emergency. I mean, it certainly will go on for a while, for quite a while. I mean, I don't like to speculate about this right now, but it's an emergency that affects the lives and livelihoods of many different people at the same time. Also, unlike a war situation, there's no outside enemy, no clear outside enemy. There is no need for secrecy, probably a need for transparency, if anything. Whereas if you're dealing with a foreign enemy, then you want to have a secretive response. And also there is really an important role for local information gathering, what's happening within communities, as well as a need for local implementation. So all of these things are very different than when we think about emergencies like national security threats, terrorism, and so on. So I think because of that, we may not, I mean, what Ham and I say in our papers, we may not need a neo-Smithian mode of governments, but rather something more resembling to James Madison's idea of checks and balances, right? So a neo-Madisonian mode of emergency governments, if you want, whereby different branches are involved in formulating the pandemic response. And we see both engagement and resistance across branches. We think that that's probably desirable from the perspective of sort of democratic legitimacy, although there is a question, like, which is different from what Neysun would say, and what's actually the most effective pandemic response. And I guess we're only now starting to figure out what an effective response looks like. But I think at the time this crisis started, there was fundamental uncertainty over what the best response was, right? Nobody really knew what they were doing, but we knew that many citizens were going to be affected. And we also know that there were many important trade-offs between saving lives from dying of COVID-19, but also keeping supply chains running, making sure that the poorest of the poor still have access to food, that there aren't really big injustices, potentially allowing kids to continue to go to school, et cetera, right? So these are really big, important questions, trade-offs, and they are likely different across different countries, right? The situation that most people find themselves in, it's easier to quarantine yourself if you live in a suburb in America than when you're in India or in some parts of the global South. And also it's likely that different societies just have legitimately different views on how to make these different trade-offs. And I guess in circumstances like that, it may just be right to have that you need a response that's not just an executive formulated response, right? But you need different branches of government involved. I mean, you can think of different reasons why that potentially be important, right? So you have less likely to be major error, perhaps. Maybe these responses are more well-reasoned, or in any case, they may seem more legitimate because each branch of government, of course, has distinct institutional advantages, if you want. Courts are institutionally well equipped to identify the needs and interest of individuals that may get ignored when collective policies are being put in place. Legislatures are good arenas for sort of public debate and public deliberation. Subnational units are needed to implement policies, but also to provide information, right? So I think there is a case to be made, although we want to be careful in what I say or how strongly I recommend this in light of there's a separate question of how effective these responses really are. But I think there is a case to be made that this emergency governments in times of a global pandemic should really look much more like a Madisonian constitutional framework than one that's based on Carl Smith, if you want.
Thank you so much, Mila. Please, Dominique.
Thank you. And maybe I can pick up two threads. I think the thread of democratic legitimacy that Mila talks about, and then the importance of our policies and procedures actually having impact on the ground that Nneoma talked about, that ultimately our law is only as good as its effectiveness. And I think that's, I'll tell you, Fernanda, I don't have any silver lining recommendations. I've been horrified by what I've been able to see in this COVID period. But on some level, it's because our understanding that certain groups are going to face harder times, because they always do, somehow hasn't been influenced by this a huge literature of intersectionality that says these groups may experience challenge that's unexpected, or it's not just harder, it's not just accretive, it may actually be qualitatively different. They may face extreme vulnerability in ways you may not predict. And this kind of intersectional understanding that we don't just have harder times because we're poor, but that race may play into it, gender, sexuality, all sorts of other issues, documentation, immigration status, particularly in the West, right? This was somehow lost in a lot of our conversations, and yet the legitimacy of governance has a lot to do with how people experience it on the ground. There's a reason nobody's trusting, according to an article I read yesterday, the US government right now, and people of African descent refuse to participate in COVID trials because there is a perception that the government may have forsaken its legitimacy in favor of, a set of other political priorities that put some of our lives in a balance. And so I think just to pick up on Nneoma's point about, we have to make sure that these policies and procedures that we write actually translate to something real on the ground. That has a lot to do with the need to make sure that impact really drives our understanding of what's adequate. But then I think as importantly, the need for us to truly interrogate our assumptions. In Brazil, there was a ruling that essential workers should go back to work, right? And that meant domestics, and largely a lot of people of African descent went back to work. A 5-year-old child who's at work with his mother, because of course the schools are closed and the childcare is closed, starts getting on the nerves of her employer while the mother's out walking the dog, and this kid, Miguel, gets put in an elevator by the employer, sent up to the 9th floor, and falls to his death. And Brazil will say, well, that's, this is an individual case for the justice system. If you work on racial justice, you understand that Miguel and his mother Mirtes, they represent a risk pool that's been unconsidered as policy was developed. In the US, we had a child in Michigan who had ADHD, attention deficit hyperactivity disorder, and had been on probation from a juvenile court judge, and was ultimately remanded to custody, sent to juvenile jail because she wasn't waking up on time for her classroom Zooms and because she wasn't getting her homework done. Where a lot of us, or a lot of adults in the room, know how much we've struggled to maintain our responsibilities, to be on Zoom all day, to remember and to keep our calendars going, even as the natural progression of walking from place to place or leaving your house hasn't really helped us, right? And so on some level, we see a lot of the hypocrisies and the inconsistencies with what certain people are expected to do versus what others are, right? Like, I've had a lot of legal colleagues who say, yeah, I can't be involved in any meetings or responsible for any production of work because homeschooling, right? And where they continue to collect salaries, they continue to receive respect in their field. And that's fine, right? We should actually be accommodating emergency. At the same time, some people have experienced this emergency without the level of patience and forbearance. And that's a space for us to interrogate. That's a space for us to interrogate our assumptions and to understand that although we don't see ourselves as racist, that is actually racism. Because we've seen in this pandemic specifically, that although people of African descent, and I'll even broaden this, Indigenous people, Latinx people, you have people who have experienced increased risk along all lines, right? These are the people who are disproportionately grocery delivery people and home health care workers, and people making it possible for both the healthcare infrastructure and society to be kind of selfish, to take care of ourselves. At the same time, there's been no recognition of the increased risk that these populations have taken in almost, in maybe involuntarily, but in service to their countries, right? And so where social protection and social programming doesn't follow the clear indications of enhanced risk, we know there's something wrong there. And yet we've seen documented racial disparities in the US, in the UK. We've seen anecdotal racial disparities in a lot of other places. We've seen Peru, which Mila talked about Nneoma talked about as a particularly hard hit space, made a choice not to keep data disaggregated by race along to understand how Afro-Peruvians might be experiencing things disproportionately. We've seen that these racial disparities exist, and yet there's been a lot of political decisions to disregard how the enhanced risk of certain populations, especially along racial lines, and the racial lines that have allowed us to continue to exploit people, to disregard and think of them more disposably, we've seen how those enhanced risks have not necessarily translated. I mean, in fact, almost nowhere from what I can tell, have we seen enhanced social protections or even targeted social protections. There was a medical journal article a few months ago, saying, yes, we're seeing an enhanced risk among healthcare providers. In our interventions, we should actually ensure that among those who were early tested include healthcare providers of African descent who face increased and escalating risks. So some people are making those recommendations, but we certainly haven't seen that translated into policy. And on some level, the disregard of documented risk certainly indicates that we need to look at why are we so willing to see Black and brown lives as disposable in that we won't actually even just equalize the amount of risk that they're taking.
Right, thank you for this non-silver lining, but very good suggestion of rethinking risk and the politics of risk and the law of risk along racial lines. Please, Neysun, go ahead.
You know, so the fundamental concept that drives US administrative law, in my view, is the tension between democracy and expertise. And it's interesting because a number of the comments so far from my fellow panelists have been emphasizing the need for greater democracy in government responses. But from my own vantage point, in light of the essays in our series, in the regulatory review in particular, I think I am tending towards recommending a greater role for expertise in government responses to the pandemic. And in particular, in those countries like the US in particular, that have seen in recent years their regulatory systems increasingly move away from putting importance or emphasis on expertise, where you have, you know, scientific authority increasingly questioned across the board within our own regulatory culture in the US. And maybe this is a very specific US point. Maybe there's some parallels in Brazil or the UK, some European countries. Maybe it's not throughout the world. But at least for the US, which I know best, and for some other countries as well, there has been this move away from putting emphasis on expertise in how regulation proceeds generally. And it seems like that has been a particular point of weakness in this pandemic response. And so my hope from that vantage point is that this crisis can fuel a shift of the pendulum. And it always has to be a pendulum, because that's sort of the dance of American administrative law, of moving between those poles of democracy and expertise, that this crisis can move us back towards that. A reason why I could be dismayed by that possibility is the reaction to the financial crisis in 2008, which very easily could have had the same impact, but it seems that the financial crisis of 2008 actually fueled this wave of populism, not just in the US and other countries as well, which cuts against the point that I'm making now. And so I guess what would be interesting intellectually is, will this crisis be the same? Will we see, you know, another, because of the way that this is being felt by people, that we're going to see another new push towards, you know, anti-science, anti-regulatory, populist sentiment in all these different countries? That could very well happen. The only real example I have for thinking that maybe this could in fact produce an opposite reaction is just the example of the New Deal, right? In the US, it's out of the, I mean, maybe that's the, I don't know, I'm not a historian. I know there are other people on this who are historians, but maybe a lesson from that period is that if it's really bad, like if it's in a really bad situation, then there's a role for expertise in getting us out of that. And of course, I'm sure that historians will take issue with that. So that's what I'm thinking about, at least from an administrative law standpoint, is trying to reinsert the role of expertise in regulatory process, in particular in the US. I do want to make a second recommendation as well, which I think is basically pandering to the audience of the American Society of Comparative Law, but it's important, and so I feel like I want to say it, which is that this experience, and I know Kim asked a question that in some ways connects with this as well, the fact that all these different countries are now dealing with this, and that's in and of itself, I think, an impetus for thinking in comparative terms. But as a China scholar in particular, I cannot tell you how incredibly frustrating it is to hear, for example, Bob Woodward, his excuse for why he didn't say anything about what President Trump told him in February that was at issue, that was in conflict with what President Trump was saying publicly. His Bob Woodward's stated excuse, which is completely accepted amongst all the different interviewers that I've seen him say this to, is, oh, well, that was happening in China. And for me as a China scholar, that means nothing. Of course, like if it's happening in China, it can happen here too. There's no reason for us to think that just because something's happening in China, it doesn't mean anything, it's cabined, it's something that's never going to affect us. And so, you know, I hope that one thing that can come out of this, and that the whole world is dealing with it now similarly, is to kind of break down those, you know, incredibly stupid mental blocks that prevent us from seeing problems that happen in one country as very easily happening in our own country as well.
Thank you, Neysun. And as we're going into our third peak of COVID, that's very important. Okay, we have 10 minutes left. I want to pick 3 questions in the Q&A box for all of you, and then give all of you 2 minutes. And we can go in the order that we had our initial questions, or whoever wants to speak first. Let me ask the first question from Athena Safita, who says, the great question for many constitutional theorists was whether should be the courts or the national parliaments who should have the institutional role of controlling and modifying measures on COVID-19 pandemic. What is your opinion? Then the second question from Miguel Meya is, do you think that the taken actions of the pandemic violate human rights or the emergency and suspension of purpose of these measures are really efficient and therefore could be justified by efficiency? And the last question from Kim Shapley that Neysun already measured is in response to Mila's comment about why this emergency is unusual. Could be that all countries are going through this at the same time, and so therefore each country's response is judged against all others, which in itself provides a sort of check. And let me add one more from Athena, which also addresses something that we talked about in development and in international human rights. Data gathering would be useful in examining how many people of color lost their jobs, mixed color society, in measures taken by private and public companies in response to COVID crisis. This could lead to assumption about racial justice and the pandemic. Okay, who would like to start? Shall we go in the order? I'll give you 2 minutes each, and then I will pass the conclusion to Maximo Langer, who's been here throughout. Please, Nneoma, you want to start?
Fernanda, I was just thinking, because a number of the questions sort of relate to constitutional theories. Perhaps some of our experts on constitutional law could dive into.
Please, Mila.
Okay, so thank you for the question. So as to the question of whether courts or national parliaments are better suited to modify the pandemic response, I mean, I think they each have their role, right? I don't think it's a question of either or. Each of these institutions have their own strengths and weaknesses. I think courts are particularly important in bringing us information on individual rights violations and individual situations in many cases. They're also able to reason well, to force the executive or legislatures to explain themselves, right? So I think there is a role for courts, but there is also a role for national legislatures in that they are obviously ultimately the ultimate democratic forum in a country, and it is important that there is a legislative basis for many of the responses. I mean, I think it's actually, for example, when the Constitutional Court of Kosovo said, you can't lock down based on an executive order, you need to pass legislation, right? As I was discussing this with people, the response varied between, well, that's just jumping through a procedural hoop, it means nothing, to, well, actually, that's really quite important because that means there is democratic legitimacy and there's wider support, right? And I think you can debate that, but I think there is a role for court, there is a role for legislature. Sometimes the role for court is to force the involvement of legislatures, right? So I think it's not an either or question. The question, I mean, this may also be part of the question for Dominique, and one observation I wanted to make is when you hear me and Dominique talk, in some ways we're sort of ships passing in the night, because I'm like, hey, there's been courts and they've been trying to protect individual rights in some cases. And then Dominique is saying, but there is all these untold stories of people that are disproportionately affected and they may not actually go to court, right? So, and I think both of these stories are probably true, right? I mean, or at least they're not mutually exclusive, let me put it that way. So I think it's partly a question of where you look and who you talk to and what kind of data you gather, right? So I just want to say that as an observation. But do COVID-19 measures violate human rights law? I mean, in some cases, yes, right? I mean, the analysis in most countries is something as follows, right? Like, rights are never unlimited. They can be restricted in some cases, but when you do restrict them, the measures have to be necessary, proportional, or reasonable, and they need to be based on law in most systems, right? So the answer is it depends. Efficiency, I don't know exactly what you mean by efficiency, but that's not an efficient, like, it's not usually something that we take into account when you're doing this kind of balancing, but public health is obviously an important competing consideration. So I think that's important. And as to, I think I reached my 2 minutes. I probably should.
Great. Maybe we could pass it. I'm sorry, it was Miguel, it was the effectiveness instead of efficiency. So maybe Neysun could go into that, right, into just because of the Chinese example that.
Mm-hmm.
Very good.
Sure, and I think I also especially want to respond to Kim again, because I just think that's such an important point for this audience in particular, that we are living in a really unique moment where probably for the only time in most of our lifetimes, the entire world is going through a crisis very much the same, in very much the same ways at exactly the same time. And it's forcing even just people who, you know, not us as comparative legal scholars, but just ordinary people into thinking about, you know, different countries and their different responses. And, you know, Kim asked whether this would serve as a sort of check. And that seems quite plausible, but not inevitable, right? That if that's something we want, actually, if we want the ability to compare different countries to serve as a beneficial purpose in the response of any given country, that is probably going to be the job of us as comparative legal scholars to tease those out. Because, you know, we see that politicians can manipulate examples of how different countries are dealing with things. You know, so in our own country, when New Zealand has a jump of 2 cases, but is then used in political discourse to say, oh, there's also a jump in New Zealand, it actually needs people who are, you know, pretty knowledgeable. And that's obviously just an example that I picked up out of nowhere. Not nowhere, but it's not the best example for the point. But the point simply being there needs to be some translation done by comparative legal scholars. And that goes to, you know, to tie back to China. For those of us who work on Chinese law, it's important for us to be able to convey what are the things that the Chinese are doing that are effective and potentially good to learn from, and what are the things that they're doing that are problematic. And because Fernanda is giving me the time signal, I know I don't have enough time to fully flesh that out, but I just want to cabin that as saying that's a better example than my New Zealand example. That's where real comparative law expertise can play a productive role in drawing the right lessons from how different countries are dealing with the pandemic.
Right.
Can I add one sentence?
No, I need to give the to Dominique, because please go ahead, because we're finishing and I need 1 more minute from Maximo, please.
No, I think I'm going to push back a little bit on what Neysun says, because I actually don't think we're experiencing this similarly. And in our report, we talk about the link, and that race is a through line between COVID-19, the state impunity, most evident through the police, but also through doctors and others, and global protests, which we saw global protests in state capitals around the world, and every state capital in the United States. And that reality that that we can't actually ever effectively balance human rights with effectiveness or efficiency, because at the end of the day, maybe to uplift something Neysun said, we don't often defer to expertise. Instead, we're making political decisions that defer to certain people's interests in very different ways. And so to balance effectiveness in human rights, which is not the way we talk about human rights, to be super clear, but to balance that, people like me know what that looks like. We routinely are disadvantaged in that analysis. And so when we talk about the problems of taxonomy that leave room for racism and interstices, when we talk about the ways in which human rights should be used to really uplift the race-based disparities that are really creating different experiences in COVID, a lot of that is about recognizing that this is a moment that's being experienced quite differently by Black and Brown people who are being refused medical care, who are dying outside of hospitals after being refused a test, and people with resources, even in very developed, rich countries.
Great, thank you so much. I'll pass it to Maximo Langer. I think we reached the conclusion because we're gonna finish very soon. So I wanted to thank all our panelists. You guys were terrific. I'm sorry there wasn't enough time, but please, Maximo.
No, yes, I also want to thank all the panelists for the excellent and important presentation. I just wanted to tell the audience what's coming in the rest of the conference, because again, it's our last plenary. So please remember, there are 2 concurrent panel blocks that are coming. We have 12 wonderful concurrent panels, so I encourage people to attend. The first block starts in half an hour, 3:30 p.m. Eastern time. The second one starts at 6:10 p.m. Eastern time. And then the other thing I wanted to say is that tomorrow we'll have the YCC conference, the Younger Comparativist conference. We are very excited about the fact that it's back-to-back with the annual society, with the annual meeting of the society. So the program of it and the link to register are at the bottom of the annual meeting conference, okay, in the UCLA website. If anyone cannot find it, just send me an email or send an email to the organization. So again, once again, thank you all for coming. Thank you to our wonderful panelists. Thank you, Fernanda, for the moderation. And we'll see you all around.
We did it.